We have already seen that the distinguishing feature between a trademark that is registered and a trademark that is not registered is the fact that it becomes easier to enforce a trademark that is registered. For instance, while filing an infringement suit, the person who owns the mark can file the infringement suit at the place at which he resides. In the usual course, it should be done at the place where the infringement is committed. In most cases, it could be the place where the infringer resides or carries his business. So that's one distinct advantage, the fact that the right holder can now choose the jurisdiction, or he can choose where to file the case. The second advantage, as we have already seen, is that registration, the fact that you have registered your mark, will not require you to demonstrate goodwill or reputation tied with a mark, which you should demonstrate if you try to enforce an unregistered mark. The third advantage is that registration can be done even in the case of a proposed use. You plan to use a mark in the future, you can still file and get it registered. So registration has its distinct advantages. Now, how do you register a trademark in India? So the process of registration involves few steps. The first one is filing an application using the prescribed form and paying the prescribed fees. Now this can be done manually, it can be done by post, and it can also be done electronically. Once the application is filed, the application is examined and there is a publication. And when it's published, the application is put to notice to the world at large. So there is an observation period, following which there could be an opposition. Now opposition is soon after the publication. Any member of the public who is interested in opposing the mark may lodge an opposition, and there are grounds on which you can oppose a trademark. So the office will look into the opposition, and then once the opposition is overcome by the applicant, the office will register the trademark. Now the registered trademark is valid for a period of 10 years and it can be renewed every 10 years. So the renewal is done by paying the prescribed fee, and it can be renewed for a further period of 10 years. Now when you file a mark, a trademark, you need to identify the goods and services for which it is applied for. So we have an international classification system, and the international classification system is called the NIS classification, which was established by the Nice Agreement in 1957. This was an agreement entered into by various countries, and it happened for the first time in Nice, which is a city in France. So it takes the name from the place. The NIS classification is a system of classifying goods and services for the purpose of registering trademarks. For the purpose of registering trademarks. The classification system is updated every 5 years, and currently we have the 10th version of the NIS classification. The system comprises of groups which the NIS classification system classifies products into 45 classes and allows users seeking to trademark a good or a service to choose from these classes which may be appropriate for their product or service. The NIS classification system is administered by the World Intellectual Property Organization, or WIPO. And if there are any disputes in the classification, it is settled by the registrar. So though we follow the NIS classification system, the classification system is also a part of the trademark law in India. So any application has to mention the particular class to which the goods or the services belong to, and whether the use is a current use or whether it is a proposed use. When an application is filed seeking a trademark, the registration could be refused for certain grounds. So there are certain grounds on which a registration can be refused. The absolute grounds on which a registration can be refused relate to inherent objection to distinctiveness and certain public interest objections. Now, if the mark is not capable of distinguishing goods and services, it is inherently not distinguishable, or it does not have distinctiveness, that could be a ground for not registering it. The mark not having a distinctive character, in the sense that it is not capable of distinguishing goods and services of one person from those of another. Similarly, when the marks exclusively consist of things that designate kind, quality, quantity, intended purpose, values, geographical origin, characteristics, the mark will not be granted a registration, because these are things that are common to every good or service in that industry. For instance, if there is an aquatic equipment, the aquatic equipment needs to be waterproof or water resistant. So you cannot sell aquatic equipment saying that it is water resistant or waterproof. So that's an inherent quality all equipment that has to be used underwater should satisfy. So you cannot use as a mark something that designates the kind, quality, quantity, intended purpose, value, geographical origin or characteristics, as these are common to all goods and services in that particular segment. Marks and indications that have become by custom a part of the current language, or that are bona fide and established practices of the trade, cannot be granted registration. Marks that have become a part of the language, for instance, dictionary words or words that are currently used in common parlance, are words which people understand as common nouns. Now, you cannot have a trademark using something which is a part of the common language, because the understanding is that it belongs to the public domain. And while granting a trademark, you are trying to create special private rights on a particular mark or a word with regard to a goods or a service. So anything that is a part of the current language, or that is an established practice of a trade, like a safety measure, or the fact that something is efficient or something is faster, quicker. Now, all these things are understood as a part of the trade. They cannot be marks which indicate what is customary or what has become a part of the trade. However, certain marks shall not be refused registration. Marks that acquire distinctive character as a result of use. So they could be a mark which refers to something that is generic, but over a period of time it acquires a distinctive character. We had mentioned in some cases metro, which even refers to a mass transit system, can be used and has been used as a trademark when it comes to footwear, when it comes to hotels, when it comes to hotels and restaurants, as well as for hospitals. So in cases where they've acquired a distinctive character, even though they could be refused as an absolute ground, they will be granted a trademark. And that has to be demonstrated that as a result of constant use, the mark, though it belongs to an absolute ground of rejection, that the fact that it is descriptive or it does not have distinctiveness, it has acquired a distinctive character. So that has to be shown before the trademark office. Similarly, well-known marks shall not be denied a registration, because the fact that they are well-known, they could be used for any category of goods and services. The distinctive character should have accrued on the mark before the application for registration. So it should not be that the mark is applied for registration, and then over a period of time, the mark acquires the distinctive character. Rather, it has to be before the application for registration. Marks that are likely to deceive the public or cause confusion will not be registered. Marks that contain or comprises of any matter likely to hurt religious susceptibilities and sentiments will not be granted a registration. Scandalous or obscene matter will not be granted registration. And matters prohibited under the Emblems and Names Act, for instance, the Indian flag or the national emblem, the Ashoka Chakra, will not be granted trademark registration because they are protected under the Emblems and Names Act. And as we have seen already, a mark shall not be registered if it consists exclusively of shape of goods which result from the nature of the goods themselves, shape of goods necessary to obtain a technical result. We had mentioned this in the context of flasks, which traditionally have a shape where it has a broad body and a narrow mouth, and shape which gives substantial value to the goods. All balls need to be round. So any shape that gives substantial value to the good cannot be a subject matter of registration. There are also certain relative grounds on which registration can be refused. Now, registration will be refused if some other proprietor or owner has an earlier conflicting right. So the day you file an application for a mark, there is another person who has been using that mark before you. So that could be a relative ground for registration, largely because of a prior or a conflicting user. Now this can fall into two categories. One, there is an earlier trademark in place, or there are earlier rights. A person has been using a particular mark, he has a right to use the mark, though they may not be an earlier mark registered itself. And trademark shall be refused subject to certain conditions. So if there is going to be a rejection based on a relative ground, that will be subject to certain conditions. Another ground for rejecting a trademark is where the earlier trademark is well known. Use of the latter would take unfair advantage or would be detrimental to the distinctive character or reputation of the earlier trademark. So when you have a well-known trademark, the use of a latter trademark would be seen as taking an unfair advantage, or it would be detrimental to the earlier trademark. Now, for this, the mark has to be identical or similar to the earlier trademark, and it has to be registered for goods or services which are not similar to those of which the earlier trademark is registered in the name of a different proprietor. Similarly, no registration will be granted to a trademark whose use in India is prevented by the law of passing off. So there is a prohibition in the law of passing off from using that mark. So such marks will not be registered, and the law of copyright will not allow such mark to be registered. So these are additional grounds on which a mark will not be offered registration. Now there are some exceptions. A proprietor of an earlier mark consents to the registration. So in such cases where the proprietor of the earlier mark gives his consent, you could still have a registration. Refusal of registration shall not be done unless an opposition is raised. So there has to be an opposition to the grant of a mark, and only then the mark would be refused. In normal course, the mark will get granted, but refusal of registration under the relative grounds has to be done by an opponent. An opponent has to raise these grounds. A mark will not be granted registration if it is likely to cause confusion. Likelihood of confusion is yet another relative ground on which a mark can be denied registration. Now this can arise when the mark is identical to an existing mark, or it is similar to an existing mark. Honest concurrent use occurs when a mark is used by two owners at the same time. In the case of a honest concurrent use, the registrar may permit the registration by more than one proprietor. So here is a case where two people are allowed to use the same mark, which are identical or similar in respect of the same or similar goods or services. So there could be cases where two parties have been using the mark at the same time or around the same time, and one party approaches the registrar for a trademark. The registrar would grant the trademark to that person, but the registrar will not stop the other person who has been using it if he is a honest concurrent user. Now the test is that they should have been using it around the same time and the mark should be identical or similar. So you have two proprietors, one or more proprietors, identical or similar, and they should have been used with regard to the same or similar goods or services. Now the registrar can subject the use to certain conditions and limitations. For instance, if the users are in India, in two different states, the registrar could set a limitation that each of those parties will confine their usage within particular geographical limits. So those limitations can be set by the registrar. Now the effect of registration is that you can initiate a suit for infringement. If you don't have a registration or if you don't have a registered mark, then you can only file a case of passing off. It gives exclusive right to use the trademark in relation to goods and services for which it has been granted, and to subject to any conditions or limitations that could be imposed by the registrar. And registration is prima facie evidence of validity. The fact that it is registered, it is understood that the trademark is valid.